Okay. I hope I can be heard. If somebody can let me know one way or another, I would appreciate that. Let's see. We have 0 viewers at this point. So, are we expecting? I don't know how to start the recording. Is it recording?
I believe it will record automatically. Let me punch up Carrie Ellen.
Oh no, the profanity filter's off. I'm not sure I can do this. Didn't realize I had a profanity filter. Okay, we got 2 viewers now. Hopefully people can hear me. Testing. All right, Carrie Ellen says nice balloons, and we can hear you. Great. All right, so we got the balloons here. We're having an open house in a couple hours here at our new Brookfield location. So we've got the place all spruced up and ready to go. All right, today probably going to be a short session. We've got scheduled until 2 o'clock. It is just 2 minutes after 1, and we're going to get started. And what we're going to talk about is estate planning and issues that you can have if you're in a long-term relationship, an unmarried relationship, as well as things that to be concerned about if you're getting divorced. So if you've been married and now you're getting unmarried, legal problems to worry about. It doesn't have to do with divorce. It doesn't have to do with anything like that. It mostly has to do with death or incapacity. What happens if you become incapacitated or if you die during a long-term relationship or during a divorce, a pending divorce. All right, so my name is Dan Krause. I am an attorney. You should be able to see that on my screen. I am an attorney. I practice law in Wisconsin. Some of the stuff that we talk about is probably going to only apply to Wisconsin, or it may apply to other states, but I don't know which states those are because every state has different laws. So if you are listening or watching this from another state, take this with a grain of salt. There's probably some pretty good ideas here, but it may be different where you are. So that's just a warning. Now let's talk a little bit about people in long-term relationships. More and more people are getting into relationships where they don't get married. For whatever reason, even Gen Xers like me, apparently there's a lot more people that are just entering long-term relationships, probably after a failed marriage or something else, and then they decide to have a long-term relationship without remarrying. But this can apply to anyone in a long-term relationship, whether it's a heterosexual or same-sex relationship, any type of relationship where you have a loving bond but are not legally married. We deal with these cases sometimes where a person dies. So, for example, we had a case, an unfortunate case, and a lot of the cases that we have are unfortunate because people died or become incapacitated. When a woman died, she died suddenly in her 60s, and she had been in a long-term relationship more than 25 years with this person. They shared some things. They both had their name on the house that they'd been living in for a long time. And after she died, it was discovered that he was not the beneficiary on all of her accounts, and unbeknownst to him, according to him, uh, he didn't realize that the house wasn't going to be his if she passed away. So the problem with unmarried people, or in this situation, there's not a problem with unmarried people, but the problem is they don't realize what's going to happen to their assets when they pass away. Um, they believed that because the house was in both of their names, both of them were on the deed to the house, um, that if one of them died, the other one would just get the house. In Wisconsin law, that's not the case unless you're married. If you're unmarried and two names are on the house without other distinguishing words in the deed, then the house just belongs half to the person who's living and half to the deceased person's estate. And then the deceased person's estate goes to whoever the heirs are, whether the heirs are specified in a will or whether the heirs are not specified and they go according to the law. In this case that I'm talking about, the woman did not have a will, so her heir was, she had no children, she wasn't married, so her heir was her mother. According to Wisconsin law, the mother was to inherit whatever was left in the person's estate that wasn't otherwise given through contracts or beneficiary designations, etc. So the mother ended up owning half of the house that the gentleman expected to be his. He couldn't afford to buy it from her. The mother also received benefits from one or more of the accounts of the deceased woman, surprisingly to the gentleman who was left holding the bag. Probably not the result that anybody in that situation would have wanted or expected. But the reason this happened is, number one, they didn't get married, which is fine, you can do that. However, if you don't get married, you need to have written documents and you need to know what's going to happen to your stuff if you pass away, if and when. Because if the woman would have had a will and said that everything goes to her longtime boyfriend, then it would have been fine. He would have gotten everything. If the woman had, if the man and the woman had specifically designated on the deed that the house was to be held in joint tenancy with rights of survivorship, that also would have taken care of the house. So the house then would have gone automatically to the survivor of the two owners. However, that didn't happen. Also, the accounts that did not transfer to the boyfriend could have been transferred if the woman had listed him as the POD, pay on death beneficiary, or the TOD, transfer on death beneficiary, then they would have gone to him. Otherwise, if she had left a will naming him as the beneficiary of everything, then also that would have worked to get him those assets. What happened was hard feelings between the family and the longtime boyfriend, negotiations, attorney fees, and etc., which it wasn't pleasant for anybody. Let's also talk about common law marriage. Laura asked a question about common law marriage, and that's a great question. Common law marriage is essentially if two people live together for long enough, they have children, or they otherwise hold themselves out to be husband and wife, and they act as a long-term married couple, etc. They own things together. After a certain period, they're considered to be married legally. Now, common law marriage is not legal in Wisconsin. It was specifically, it was prohibited by legislation, by the law in Wisconsin in 1984. So there are still several states, and I think there's probably a dozen or so that accept common law marriage, but Wisconsin is not one of those. So you can't do a divorce, and you can't treat the person as a spouse after they die in order to get their assets if you're in Wisconsin and somebody dies or becomes incapacitated. The common law marriage does not work. There are certain ways that spouses or long-term relationships can receive some of the assets of the other person in a split up. And it's not a divorce, it's called a Watts type of a claim. So there was a case in Wisconsin called Watts v. Watts, and it was two people. They both had the last name of Watts, and they split up. They were not married legally. This was in 1987, so it was after common law marriage had been abolished in Wisconsin. And what the Supreme Court of Wisconsin found was that the one party that was kind of getting shafted could make a claim under express or implied contract, or a partition action, constructive trust, or what was really the main issue here was unjust enrichment. That if two parties work together, one of them may have raised the children, foregone going to school or college because they were working on the relationship, and then the relationship ended later and they ended up with nothing in their name, but they had put so much into the relationship, then they could say that they were the other party was unjustly enriched by their actions of taking care of the kids without having to get a babysitter, to take care of the person, take care of the house, to do all of these things. And so that the person was not allowed to just take all of the assets with them. It was unjust enrichment, and they had to split the assets for that reason. Not the same as divorce. There's no way to get child custody there, or even spousal support or ex-spousal support like that, but it's just to divide assets. It's also a little more difficult than a divorce because it's not as well defined. So that's a little bit about common law marriage. Do not count on a common law marriage in Wisconsin. In fact, most states do not count on common law marriage. Find out what your rights are, what your property is what's gonna happen to your property. Also, many people in their long-term relationships don't realize that if they get sick and they're in the hospital, their partner does not have any rights to ask the doctors how it's going, to visit in the hospital, to control anything that's going on with the other person's health. In fact, the family can just push them out and a lot of times just tell them they can't visit, etc. But if you do a healthcare power of attorney and a financial power of attorney, and you name your partner as the agent for you, then they can make decisions for you. They can get information from the doctors and nurses about your condition. They can help you, and they can do things for you that they would not be able to do because they're not related to you at all. Legally, they are unrelated. So you need to have, if you're in a long-term relationship and you trust your partner to do things for you, to make these decisions for you, then you need to sign documents in a legal way that allows them to do that. Otherwise, if you end up in a car accident or a fall or have a stroke or something like that that's immediate, now you don't have any way to give them permission to have this access to your finances, to your health care, to your doctors, nurses, etc. So do powers of attorney for finance, do powers of attorney for healthcare. If you're in a long-term relationship and you don't want to get married, do all of these legal documents to make it as close to marriage as you can, but it's not a marriage. Allow your partner to make decisions for you. You know, specify what they can do and what they can't do, just in case you die or become incapacitated. All right, that is long-term relationships. The bottom line is do estate planning documents. Include your partner in these documents. Both of you should have the documents just in case something happens to one of you. You don't want your family pushing your partner out of the way in order to make decisions for you when you might rather have your partner do it. So let's talk about divorcing couples. Now, Wisconsin has a law like a lot of other states do. I like Wisconsin's. It's nice, it works. The law is that if you're divorced, that means the divorce is final, then anything that you wrote in your will, anything that you wrote in a life insurance designation, policy designation, anything that you wrote as a designated beneficiary on your bank accounts or your retirement accounts, it all gets wiped out if it has to do with your spouse. People don't realize this. It makes a lot of people feel a lot better when they come to see me that their divorced spouse is no longer their beneficiary under their will, even though the will is 20 years old. It says their spouse gets everything. They don't. It's not legal anymore after the final divorce. In fact, anything that you mention about your spouse as being your executor or personal representative or power of attorney agent, that's all wiped out. And in fact, any of your spouse's relatives. So if you named your spouse's brother or sister or mother as your agent or as somebody who's going to get property on your death, they are also wiped out. The law has to treat it like they had died immediately before your divorce, and so then it goes to the next person if you had an alternate on the list. That's a nice thing about the Wisconsin law that allows revocation of all those designations for the spouse and the spouse's family, or the ex-spouse and the ex-spouse's family. Where we run into problems sometimes is that divorces sometimes take a long time. Some divorces take years, in fact. Even for quick divorces, depending on how things work out, you may not want your spouse to get things if you die during the pendency of a divorce. A divorce is a very stressful time. Unfortunately, many people commit suicide during divorce pendencies. Many people have heart attacks, strokes, etc. And the law does not protect them like they do for a divorced couple. So if you're already divorced and it's finalized, then the law protects you. It wipes out the spouse's name or the ex-spouse's name off all your documents. However, the divorcing couple is still married. Under the law, everything is still the same as it was before they started the divorce. Now, sometimes divorce has interim orders. So before the final divorce, the assets can start to be divided, and things can be, they can have an interim division. But that's not the same. It's not the same as wiping out your spouse off of your estate planning documents. So that if you wind up in the hospital and you can't talk during your divorce, your wife or your husband, who you don't get along with, may be the person who has the power to make medical decisions for you. I'm sure a lot of people would not want to have their divorcing spouse have the ability to pull the plug or to make that decision. You might rather have a family member, your parent or a brother or sister, or even a child, make those decisions instead of the person that you're having a stressful division with. So there's also a question from Carrie. If I haven't filed for divorce yet, um, can I change my estate plan to have my assets go to my children instead? The answer is yes, you can. Um, but the more complicated answer is there's a lot of stuff that you own, especially in Wisconsin, that your spouse also owns. So you can't give everything to your children. But you can disinherit your spouse to the largest extent allowed by law, so that you can give all of your share of the marital property to your children. You can give all of your individual property, and we really don't have time to go into what's marital and what's individual and how can you tell the difference. The marital property law in Wisconsin, the handbook is 3 volumes. So telling what's marital and what's individual property and what's mixed property, it's a little bit complicated. However, you are allowed to give stuff to people besides your spouse. You can't give your spouse's stuff away to anybody else. So in Wisconsin, typically your spouse owns half of everything. However, if you had a prenup, or if you had property that you brought into the marriage that you've kept separate, or if you've inherited property or had property given to you during the marriage and you also kept that separate, that is individual property, and you can give that to someone besides your spouse. However, a spouse has certain rights to claim certain property. Now, the spouse can claim, I think it's up to about $9,000 worth of household goods and furnishings. So whatever's in the house, generally the spouse can keep without having to pay anything for that. The spouse can keep the homestead. Now, they can't keep the homestead without paying. The law says that they have to pay for the half of the homestead if they want to keep it. So they'd have to pay for the other spouse's half of the homestead. So let's say that I had a house with my spouse. Now, normally a house held with your spouse is held as marital property, joint marital property, which essentially means that your spouse is going to get it no matter what if you die. However, you could sever that joint tenancy in different ways, and we won't talk about exactly how that is, but then you could give your half to someone else on your death, not your spouse. So yes, you can leave your assets to someone beside your spouse. In Wisconsin, it's typically going to be limited to whatever half of everything that you and your spouse own. So yes, the answer is you can disinherit your spouse. You can give the assets to someone beside your spouse. But there's certain things that you can't change without your spouse's consent. Now, one of those things that you can't change without your spouse's consent is, in Wisconsin at least, is your retirement accounts. In order to change beneficiary on your retirement account in Wisconsin to name someone beside your spouse has to sign off on that. That's unfortunate because many people separate from their spouses. We've had a case recently where spouses hadn't been together for more than 10 years. They were estranged. They didn't really even know where the other person was, but they were still married, and one of them died. Now, what can you do? Well, we got to wade in there essentially with hip waders and try to figure everything out. It's going to be expensive and time consuming. Oh, great. My mom says, great presentation. Thanks, Mom. Appreciate that. All right, so those are the main topics. The essentials are, if you're getting divorced, do some estate planning to change who gets everything, so that you can make some plans for your kids if you don't want your divorcing spouse to get everything that you have. And the other point is, the earlier point is, if you're in a long-term committed relationship and not married, Also do some estate planning so that your long-term committed partner can have some sort of access to you, have some sort of control that you might want to give them if you become incapacitated, or can receive things on your death if you die. All right, so this is a fairly short presentation. We've got very few viewers. I think I know everybody who's on here right now. So we're going to wind this up. Does anyone have any final questions or comments, or would you like me to wax poetic on anything further? Going once, going twice. Okay. Thanks, everybody. Appreciate you. Oh, wait. Thank you for the information. Scary to think of things being not in your control. That's true. Please keep things in your control. Estate planning and estate planning documents help you to make sure that what you want to have happen actually gets done, and gives the power to the people that you want to have the power, not the people who the law says should have the power. Get yourself away from what the statutes say. Write it down for yourself so it's enforceable. All right. Thanks, everybody. I'm going to end the live video.